guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Sarah Boone, otherwise known as the suitcase murderer, killer, or some also call her some other things, but at this point she's an alleged murderer of her boyfriend, George. She was back in court this morning in Orange County, which of course is about in my county and about 30 minutes from me, the courthouse. And it looks like we are still playing the waiting game as far as her trial is concerned. Again, her defense attorney, Bankowitz, is having trouble getting the JAC to approve the rate that this expert that's going to testify for Boone in her case for her battered spouse defense approved. And I'm going to actually go over that as soon as we watch this clip here from Court TV.
Boone 2020 CF 2603. Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10-10-77.
All right, we're here for a status hearing on your case. Your case was set for pretrial conference back on July 12th, but as I promised you, I was going to bring you over, so whatever the things that we normally discuss at pretrial would be discussed while you were present in the courtroom. Mr. Bankwitz, in court, you previously discussed an issue with getting JAC to pay your expert, I'm going to just paraphrase, for this battered spouse defense.
And they have filed a formal objection, which now has been set for hearing. I want to say September the 18th, the first available time, because they have to have, they require 20 days for hearing purposes, and we couldn't get on your docket before that date.
All right. So, Mr. Cacciatore, Ms. Boone's present. Mr. Bankwitz is asking to continue the case so that he can, we're going to have a hearing with JAC on his request for funding for a defense expert. Given my understanding of the case, that defense expert would be crucial to at least one defense that's going to be offered in case. And my understanding is you can't do anything until that expert actually is identified as a witness who's going to be called, correct?
That's correct. She has been identified.
I understand, but it's not unknown at this point whether she's going to be called, and I assume since there's no agreement as to payment, potentially there's going to be an issue with the state deposing her at this point in time.
Correct.
So that's what I meant by he can't do anything until you get to the bottom of what she's going to be paid and whether she's willing to formally accept the case. Is that a fair statement?
Semi-fair. She is formally willing to accept the case. The issue is the hourly rate. JAC hasn't changed their hourly rate for this area of expertise for over 10 years.
So, Mr. Cacciatore, the request is to continue so that that issue can be resolved. Do you have any objection to that?
No, Your Honor.
All right. I'm going to grant the request to continue under the circumstances. What's the hearing date that we're currently working with, Mr.
I want to
Brown?
say September the 18th, Judge.
That sounds like what my JA told me as well. For control purposes, I'm going to set the case for my September 20th pretrial, October 2nd trial period, with the understanding that we can potentially address pretrial. And I understand that you're unlikely to tell me that you're ready to try this case on October 2nd, regardless of what happens to the 18th.
Correct.
But I just want to have the case scheduled close in time to the 18th so we can address them at the same time.
Thank you, Judge.
All right. That is the order of the court. Ms. Boone, you'll be returned to the Orange County Jail while Mr. Bankwitz continues to prepare your defense. All right.
Judge Boone.
Thank you, Judge. Have a good week.
Hold on one second. Ms. Boone, I've addressed pretrial. I've brought you over. I'm going to give you a moment if you want to share something else with me, but that's what I needed to address today, and I've got other matters that I need to address in short order. So,
I understand, and I'm grateful for your time. I had previously sent you a letter, and it has not been uploaded, but it was made an announcement to the courtroom during my pretrial that you do have it, and I was wondering why and if it will be uploaded, because I have another copy of it that I would like to hand deliver to you today.
I don't know why it has not been uploaded. I'll have to talk to my JA about that. If you want to give me another copy, that's fine.
Yes, please.
All right. Go ahead and just tender it to one of the deputies. And actually, any objection if I just have the clerks scan it here in open court?
Yes, please. And do I normally get a copy? I haven't gotten one. I'm sorry.
Well, it'll be filed in the case.
If it's uploaded, Judge, I can make a copy and take it to him.
Okay. All right.
Yes, please. If that would be okay, I would like to have that one uploaded. It's revised.
Okay. And what I had directed my judicial assistant was to disclose this to the attorneys. Again, to a great extent, when I read the original, you've covered a great deal of ground that we've covered in open court on multiple occasions about the method and manner of communication. Having read the original letter, I did not believe there was any additional action that I needed to take, which is why I didn't take any action on that letter. All right? So to be filed, Ms. Boone will be returned to the Orange County Jail pending further order of the court.
Thank you.
You're welcome.
So we are on another delay. This one just doesn't seem to want to hit a trial, you know? And as much as I believe she's guilty, well, because of the videos she took, honestly, those videos are just so damning. She has a right, just like everyone else, to a fair and speedy trial. So the fact that this has taken so long, it's not good, you know. And they finally made the 38 pages of the motion, the ex parte for the trial that they're doing in September 17th with this forensic expert with the JAC. They did make that public on the records. Her new letter that she just handed the judge today, well, that's not up just yet. But I'm going to go through a bit of that. Like I said, it's 38 pages, so I'm definitely going to go through the beginning of it. There's quite a difference in what this expert is asking and what the state seems to be willing to pay an expert. So this is the filing. It actually was filed on the 19th. They originally had this sealed as confidential on Sarah Boone's court documents. It looks like after this morning's pre-trial status hearing, this was unsealed. So again, I'm going to just go through a bit of it here. I have a couple questions, and I'm pretty sure that the lawyer, Peter Tragos, will not disappoint, and I'm sure he's going to go through this. And I have one big question for him, and I'm sure he's going to answer it, but I'm actually going to forward my question to him because I have one major question as far as this expert is concerned. So again, this is the state of Florida versus Sarah Boone. Justice Administrative Commission's ex parte response to motion for appointment of defense forensic psychologist. Comes now the Justice Administration Commission, JAC, by and through the undersigned attorney, and files this response to the above cited motion as follows. Frank Bankowitz, counsel is seeking authorization for $15,000 at a rate of $400 per hour for services and $125 for travel time for a defense mental health expert. So that is what apparently this expert is asking for payment. Based on JAC records, the court previously appointed a mental health expert to assist the defense, albeit under prior indigent for costs counsel. JAC paid $7,500 for the services of this expert for services rendered from August 21st, 2020 through April 5th, 2022. JAC also has concerns about the rate requested for this expert. So they've already paid $7,500 to another expert for Sarah Boone from basically the end of 2020 through early 2022. So now we're talking another $15,000. So yeah, they have a lot of questions for why we're needing something that's going to cost, pretty much double that. JAC may only pay due process costs as authorized by sections 29.007, 27.40, 27.425, and 27.5304 Florida statutes. As directed by section 27.425, Florida statutes and the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract, policies, and procedures. JAC objects to any compensation rate in excess of established rates. And notice that's in bold, so they're not liking that this expert's requesting so much money. And we're about to see the rates that the JAC is willing to pay this expert. The rate for a psychological examination is a flat fee of $350. It's quite a difference from the $15,000, isn't it? For other services, the established rates for medical doctors and psychologists are as follows. In court testimony, $170 for first hour or less, $170 per hour thereafter. Waiting to testify in court, $85 per hour. C. Waiting to testify, deposition, $72.50 per hour. Travel time, $72.50 per hour. And out-of-court services, $160 for the first hour or less, $160 per hour thereafter. Counsel has the burden to establish the particularized need for expert services. Counsel's need to show the services are necessary for the defense of the case. Defense counsel also has the burden to establish diligent efforts to obtain services within or closer to the rates established by law. Well, I think it sounds like Bankowitz has been having a really tough time getting an expert to take this pay. Again, I don't know how far and wide he's gone, but he's expressed to the court on numerous occasions how difficult it's been to get someone at this JAC rate. While an indigent defendant has a due process right to the assistance of experts in his or her defense, that right is not unfettered. So basically, while she wants it and the defendant would like it, you can't just get an expert at any kind of rate. And of course, they list some court cases here. The right is limited to experts that are relevant and necessary to the defense of the case. The defendant is not entitled to a specific expert or one of his or her personal liking, but is only entitled to the services of a competent expert. As enunciated by the Florida Supreme Court, an attorney seeking due process costs has the burden to establish 1. The particularized need for the due process services, and 2. Prejudice arising from the denial of the due process services. The determination of whether to appoint an expert is within the broad direction of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and the denial of expert assistance would result in a fundamentally unfair trial. So therein is my question. Number 8 kind of gets it. If the JAC in September denies paying this expert this $15,000 that they're requesting, what's that going to do to Sarah Boone's case? And this whole line right here about a fundamentally unfair trial, that's where I'm wondering, is that gonna enter into that she's having an unfair trial? Again, I'm not experienced in that, but that's my question for someone like Peter Tragos or another attorney who is more experienced and more expert sort of field. Counsel needs to establish the need for an additional mental health expert where the court previously appointed an expert to assist the defense, and that expert conducted an evaluation of the defendant. Due process does not require the state to provide every foreseeable service to the defense. Rather, the state is only obligated to provide the basic tools of the defense. As the United States Supreme Court has explained, meaningful access to justice has been the consistent theme of these cases. We recognized long ago that mere access to the courthouse doors does not by itself assure a proper functioning of the adversary process, and that a criminal trial is fundamentally unfair if the state proceeds against an indigent defendant without making certain he has access to the raw materials integral to the building of an effective defense. Thus, while the court has not held that a state must purchase for the indigent defendant of all the assistance that his wealthier counterpart might buy, and there's the court cases they cite, often reaffirm that fundamental fairness entitles indigent defendants to an adequate opportunity to present their claims fairly within the adversary system. To implement this principle, we have focused on identifying the basic tools of an adequate defense or appeal, and we have required that such tools be provided to those defendants who cannot afford to pay for them. So, that's my big question. So, they're basically saying that, yes, but an indigent defendant has the right to a good expert in their fields, but to what end? You know? In light of the services already provided to the defense, counsel has the burden to show the need for a second mental health expert in this matter. Although counsel may prefer the services of a prominent expert, due process does not require the state to provide services that a wealthier defendant might elect to purchase. If the expert who has already evaluated the defendant can provide competent and meaningful services to the defendant, the court should not appoint another expert in this manner. I think the reason why they're needing another one is because her defense has changed. Because I believe this battered spouse defense is after 2022. I could be wrong, but I'm thinking it was definitely not at the beginning. I don't believe that was her defense, at least at the get-go. Counsel also has the burden to show diligent efforts to obtain services within the rates established by law. JAC would not anticipate paying a rate in excess of $200 per hour for a defense mental health expert, absent some specialty that justifies a higher rate. Even if the expert has such a specialty, JAC has concerns about paying a rate in excess of $300 per hour for even a specialized mental health expert. Paragraph 4 of JAC's registry contract addresses counsel's requirements when procuring an expert at rates higher than the established rates. If attorney intends to procure due process services at rates higher than the established rates, attorney must file a written motion setting forth the basis for a higher rate with service upon JAC. Attorney has a burden to establish that particular due process service is necessary to the defense of the case, and that attorney made a diligent effort to find service within the established rates. A prior authorization for a higher rate for the same or similar services in an unrelated proceeding shall not relieve attorney from diligent efforts in the case at issue. In order to obtain reimbursement, the order must contain a finding that the due process service is necessary to the defense of the case, and that the attorney made a diligent effort to find the service within the established rates. Diligent effort includes, but is not limited to, evidence that the attorney sought the services of at least 3 providers willing to work on the case, but none were willing to work within the established rates. So yeah, Bankowitz is going to have to prove at this September 17th hearing that he's tried at least 3 providers, 3 mental health experts that refuse to work with the established rates of the JAC. So that's obviously clear. So that's the basis of those 38 pages. I'm not going to go through the rest of them because it's just like the filings that he made and he had to sign attorney Frank Bankowitz, and of course his motions to the court to approve the expert that he wants for Sarah Boone's case. So again, there's quite a difference in the cost that JC is willing to pay and the rate that this expert wants to be paid. So I'm not sure how that's going to work out. And man, it seems like it's going to be quite a wait till September 17th. So again, I'm going to see what Peter Tragos has to say. I'm going to drop him a line and see if he's already planning on responding to that in a video of his own, or I would love to get him here on the channel actually to discuss the Sarah Boone case. That would be amazing. But in the meanwhile, looks like September 17th, they're looking to try to see if the JAC will pay this expert and what happens from there. And we have a tentative date now for trial for October 2nd, easing closer to the end of 2023 on this one. So, yep, a lot of waiting. I'm calling this one the waiting game. But let me know what you guys think in the comments. And with that said, that's all I've got for this one. I hope you have a great rest of the day. And most of all, stay safe.